Good morning, esteemed judges, honorable Mr. Chairman, and my worthy opponents. I've come here today to discuss an issue of most grave importance, the issue of whether terrorists should be tried in civilian or military courts. I've come here today to explain the military court system to you. The military court system is inherently unjust. In military courts, there is no impartiality. All members of military courts are parts of the military. The lawyers, the judges, and the juries are all military officers. Military courts do not abide by any rights provided under the U.S. Constitution. It completely ignores the Bill of Rights. Military courts allow hearsay in this evidence, allowing for he said, she said, just rumors to come into the courtroom proceedings. Also, chain of evidence is completely disregarded in military courts. It does not matter where evidence has been or who has handled it, leading to risk of contamination of evidence. And all evidence is deemed admissible or inadmissible based solely on the judge's discretion. There is no set rules governing what can or cannot be shown inside the military court. It is purely what the judge believes should or should not be shown. Military courts also hold their proceedings behind closed doors. There's no, the public never gets to hear about it, the public never knows what goes on, and the military courts can make any kind of decision they want based on any evidence and will never know the difference. Also, in a military court, there is no system in place for challenging the appointment of members of the jury or the judges. They're appointed by orders from higher level officers, and there's no system in place to check in terms of conflict of interest or anything of that sort. Military courts are designed to try combatants and not criminals who take actions not in a non-war zone. Historically, military courts have no jurisdiction over individuals who are non-combatants. Meaning that that anyone who's not part of a friendly or enemy military force during war should not be tried in military court. This means anyone who takes action outside the field of battle. So any combatants who attack people in the U.S. and not in war zones like Iraq and Afghanistan are not enemy combatants and should not be tried in military courts. All appeals handled by military courts are handled by a military board of reviews, also staffed by military officers. This system has no impartiality. No third party can ever come in. Also, there's a fair amount of ambiguity in the conduct of military courts as well. There is no maximum sentence for crimes, so a crime can be given any sentence, including there's no restriction on when the death penalty can be imposed. And also, the courts don't ever have to warn the defendants whether they could be given the death penalty before the trial. They simply show up to the court the day of their trial and find out, well, we're trying you to see if we're going to put you to death or not. It's very ambiguous, and they just decide on the spot what they're going to do with this group of people. Also, military courts have no stance on whether the principle of double jeopardy applies to them, which means that in theory you could try the person for the same crime multiple times, which is clearly in violation of their rights. Thank you, and I hope today you have a deeper understanding of the way military courts work.
Mr. Chairman, honorable judges, and my worthy opponents, I'm here today this morning to show you how important it is for all terrorists to be tried in a military court. The underwear bomber, also known as Farouk Al-Mulad, will provide many benefits if he was tried in a military court. This case is currently being tried in a federal court, not a military court. Abu Mulad is an enemy combatant, and he should be tried in a military court so the United States can gain intelligence to prevent future acts of terrorism. According to David Rivkin, co-chair for the Center of Law and Counterterrorism at the Foundation for Defense of Democracies, states, "This is an individual who immediately upon being detained admitted he was a member of Al-Qaeda. He would possess valuable operation intelligence which will vanish with time. Civilian courts do not allow gruesome interrogations to gain this fleeting information." Senator Lindsey Graham, talking about the underwear bomber, said he should have been turned over to the military, questioned about his intelligence, what he knew about the enemy. We're trying to win a war, not fight crime, and that was a real mistake, reading him his Miranda rights. If he talks, it's just blind luck. Allowing this case to be tried in a civilian court will set a precedent for future cases. All terrorist members should be tried in military court because they are enemy combatants to the United States, as stated by the 4th Geneva Convention. An enemy combatant is defined as any person in an armed conflict who could be properly detained under the law and customs of war. Omar Albin Rahman, better known as the Blind Sheik of the 1995 World Trade Center bombing, was tried in a civil court. Because of information disclosed during this trial, bin Laden was allowed to escape because of the warning that the U.S. was after him, disclosed in the court. Because of the civilian trial, the court was not able to stop information which had critical importance to the nation's security from leaking out. This information allowed bin Laden to know that he was being targeted. As part of the civil trial, the unindicted co-conspirator list, as part of the civil law discovery, this information was given to the Sheikh's attorney, and Osama bin Laden's name was on this list. It wound up in his hand in Sudan, and he knew that the United States was following him. If this had been a military trial, this information would not have reached bin Laden, and he would not have escaped because military judges conceal all document and trial. The last time military tribunals were used was during World War II. The Germans sent soldiers to America as spies to sabotage the U.S. war effort. President Roosevelt realized that neither the death penalty nor secrecy can be guaranteed in a civilian trial, so he issued a proclamation that established the military tribunal consisting of 7 generals, the first to be convened in the United States since Lincoln's assassination. In 1 month, all of the German saboteurs taken prisoner by the U.S. of this military tribunal, the United States began to favor military. Thank you for your time.